Hello, good evening. I'm Oral Gibbs, and welcome to Speaking of Everything. With me this evening for the first time is attorney at law, Mr. Rik Bergman. How are you doing, sir?
I'm fine, thank you.
Uh,
Thanks for having me here
and
tonight.
thank you for accepting the invitation. I'm happy to have you here because you, as an attorney, is now in a very interesting area, mediation,
Yeah, correct.
and it's not something common to us here in Zimbabwe. Most of the time, we prefer to just go to court and fight it out. So tell me a little bit about yourself for us and why you decided, after all these years as an attorney, to go back to Holland and take the courses in mediation and then come back to work here.
Well, yeah, I came here in '97, and together with my partners, we built up our law firm BZSE. And in my practice, I felt the need that mediation had to be thought of, and there is a development in Holland and also in the States that mediation is very successful. And I wanted to try something new after being a lawyer for more than 20 years. So. And I think that I had the skills to be a mediator, and I tried it a little when I was dean, the dean of lawyers, and when there was a dispute between a lawyer and a client, they came to the dean to see if an amicable settlement could be arranged, or also sometimes in disputes between lawyers. So, and I found that very satisfying. So that was the reason that I thought, okay, let me try to do something new, do the course mediation, and that is what I did in 2014. Also because of the studies and research, they show that that mediation is very successful and fruitful for parties. The outcome is often more emphasis of how do you say it, embraced by parties to for a good outcome.
But at the same time, when you practicing as a lawyer is very difficult in a small community like St. Martin, where you have people over the years tend to want to settle differences in court. And you said, I read the piece in the Herald about you that you had handled already, 4 cases in mediation?
Yeah.
Do you think you'll be able to convince more people to go along that line?
Well, it is a kind of mindset that lawyers are trained to go to court. Clients are often willing to sue the other partner, the other party. And we have the facilities to do the mediation. For example, it is anchored in our law, the law of the civil process, Article 21A, says that the judge can instruct parties to go to a mediator. So that is a good anchor to explore possibilities. So the judges should and could explore possibilities to send cases to a mediator, and also lawyers can think of sending a case of trying to mediate a case sooner than to go to court. It is a different mindset because with mediation you try to come to a consensus, and you focus on what parties have in common. And if you go to court and you go to explore a legal dispute in court, then you focus on the differences between parties, because each lawyer wants to get right from the judge, of course. So that is the main difference. For example, if you look at a divorce case in a normal litigation, you focus on the divorce, the children, the alimony. And in a mediation divorce, you look more at how the future will be between the ex-partners and the children. So it is a kind of different mindset, and yeah, I think that that not every dispute is fit to be mediated, but I think a lot of cases are.
And understand that when there's mediation, both parties are not that angry with each other after it's resolved, as opposed to a court case where you won or I lost. It's a complete difference, right?
Yeah, well, I read studies about mediation, and the reason why, if you compare mediation with the normal litigation, and litigation, it is very time-consuming. It is also emotionally draining. You're never certain of your case until the judge made his verdict, and yeah, you put your faith in the hands of a judge, of course, and a one party. And the thing with mediation is that the parties, yeah, they are the players in the process, and they take the lead. And the mediator is an instrument, is a party, is a person who facilitates the process. So. And it is also in an ambience that is not really formal. It's one-to-one or one-to-two, in fact, what you say, and it focuses more on what parties have to say, what the underlying dispute is in a court case or in a misunderstanding.
What's the reaction from your colleagues?
Well, my colleagues in the office, they were very enthusiastic.
Yeah.
And yeah, they know also about the positive effects of mediation. They read about it, of course, and they experienced it. And I, from very good friends, colleagues, I got congratulations. So let's see how it works out in the practice. And I have done now 4 or 5 mediation cases, and the results were very satisfying and encouraging, in fact.
Now, your brother's also an attorney, right?
Yeah.
I thought you all were twins. You told me you're not twins.
No, he's 3 years older than I am, and we are not twins. We look alike, I know. But he is the tax expert of our firm.
And you specialized in what area before you started mediation?
I was general practice, lawyer, corporate, civil law, labor law, that area.
Okay. When you look at mediation, what you are seeing now in the U.S., and you were speaking about this before we started, Florida, big corporations like Disney are saying they want mediation before litigation.
Yeah, yeah. In fact, you have 3 ways to get in contact with a mediator. One is that parties decide when they have a dispute, well, let's go to a mediator and let's see if he can help us.
Right.
A second possibility is that you are already in a court case and that the judge asks you or instructs you to go to a mediator to see, because he or she thinks that that particular dispute is fit for mediation, and he sends the case to a mediator, and then the court case will be postponed for that while, that you wait for the outcome of mediation. And the third way to get in contact with a mediator is because of a mediation clause in a contract. And that means that parties can agree in a contract that they have, before they go to court, to go to a mediator. And I think that in Florida, before a case can be handled by a judge, I think in all the cases they have to try to mediation first. And I know that in developments in Holland, they always also try to get the possibilities more explored to get to a mediation process before they reach court.
And what I've seen in some contracts actually is that you have no choice. It's there in the contract.
Yeah, you have to try mediation.
Yeah.
You have to try mediation first before you can go to arbitration or to a civil court case or whatever.
Yeah. Now, what's the process of mediation?
Well, the process is that that if parties are referred to me, or if parties come to me for mediation, I will do an intake and sit together with both parties, or if they have lawyers, lawyers can also be part of the process.
So lawyers could be present too?
Yeah, they can be present too.
Okay.
And, although the process is focused on the parties itself, they can be there to assist the parties in explaining the legal misunderstanding or dispute. I have to say that based on the studies and the experiences, if parties do the process without lawyers, then the outcome is more effective and more efficient, because it gives parties the opportunity to talk about the problem itself, and you have the dispute between the parties, and what I already said is the focus is to get to the relation between parties and get that fixed. Not that, well, like in litigation, sometimes when you go to court and you have an outcome of with a verdict of the court, then the relationship is often disturbed or gone, in fact. And with mediation, you try to save that relationship between parties, look at the agreements they have and the consensus they have, and then as a mediator, you are trained. You have a kind of toolbox with things that you can, with techniques that you can apply in the proceedings of mediation, and that is how you go through the process. So then, that is the intake. Then what you could do is you could analyze the problem, what you're here for. Is it a divorce? Is it a labor matter? Is it a dispute between shareholders? And that is what is laid down in the contract, which contract is very simple. And the essential thing of the contract is that it is confidential, and that the mediator is going to facilitate the process. So I'm not there as a lawyer, because that is the other hat I'm wearing.
Yeah.
I'm not there as a lawyer to tell parties how it works legally. What I'm doing there in the mediation process is to guide the process, to facilitate the process, and to help parties to reach a solution. So the mediation agreement is then signed, and then you have a couple of sessions, and normally the average is 3 or 4 sessions, 2 sessions, 2, 3, 4, or 5. It depends a little on the complexity of the problem, and the willingness of parties to reach a consensus, and how far the dispute already has separated the parties. So the time needs the healing process needs some time, of course. So well, and then with a couple of sessions, I leave it up to parties to bring up the standpoints. It is mainly meant to get things off their chest, to talk about the background of the legal dispute, and after the process, giving parties a balanced background, and also the equality of listening to each other. And then the trick of the mediation is that the solution is there to be found, so it presents itself.
Now, mediation is not limited just to divorce cases, right?
Not at all. In fact, every legal dispute is fit for mediation. Like shareholders disputes, like commercial disputes, labor disputes. There are some that are not really fit for mediation, and like if it are really issues that like black and white, one party is right or the other party is right, and like if you have a boundary issue, then you can imagine that if you have the advice of the cadaster and parties have their standpoints, then a ruling should be there to determine what the boundary is. But other dispute than that, labor cases, commercial disputes, contract negotiations or interpretations. It's all fit for mediation, yeah.
What about if an individual is in a disagreement, say, with government? Can that also be mediated for you, or that's not possible?
If the government is in agreement with that,
Okay.
it could be done. Yeah.
So it's really very broad area covering all civil matters where mediation is possible.
Yeah. Also, yeah, that is possible if you look at if you have a union that has a dispute with the government in what they want to negotiate, then sometimes you also see a negotiator or a mediator to being able to help the parties. So on all kind of levels, it is possible.
And let me ask you this also, Mr. Bergman. If two parties have a dispute, say it's a business where two partners probably going at each other, want to go to court, but decide, well, let's go to a mediator like you. You require both parties to sign an agreement before starting mediation?
Yeah.
Okay.
Look, what you have to do as a mediator, you always have to look at the equalities of parties.
Can you explain that, please?
What I would prefer is that both parties come to me with a dispute or with a misunderstanding, what we say. And if both parties are there together, then they won't have the feeling that that one is already, or that I would be prejudiced because I already talked to party A or not to party B. Because if you call me up and say I have a dispute with, for example, my brother, and I want you to mediate. Then my brother could say, well, you already talked to Mr. Gibbes, so you're prejudiced, and I don't know what's the contents of that conversation. So and that is what I meant with the process of mediation and the equality of parties. You have to make sure that that each party get the equal opportunity to talk with you and to get the right attention, in fact.
But isn't that a little difficult? How do you get both parties at the same time without, isn't that difficult?
Well, what I said is, if you look at the three ways that you get in contact with a mediator,
Yeah.
one way is that both parties come together to me. For example, you have a misunderstanding with a supplier or with somebody that you have a contract with.
Right.
And emails going back and forth, and you say A and the other party say B. Well, you can have a breakthrough in that conversation that you say, okay, we are not going to solve this problem. Let's bring this matter to a mediator and let's see if he can solve this dispute. And you send me an email or you make an appointment with me, and then I will, in the first intake, invite you together to work on the dispute.
Because it's very important that both parties see at the same time, not one party before, because of that.
Correct. Yeah. Well, there are also forms of mediation that they do they do one party and the other party separately. But the way the mediation is trained in Holland, and also what I was trained for, is that you have the sessions together with parties, because then you have the maximum result in the consensus and the facilitation of parties.
Do you think you could have done this job as a mediator without going for that special training in Holland?
No, and I could also not have done it without the experience that I have.
As a lawyer?
Yeah, because I know as a lawyer what brings party to court, and also what causes can be of a dispute, the emotional impact, the time-consuming process, and the frustration of parties. So, And with the mediation, what I saw and what I experienced up till now is that you can really facilitate parties in based on your experience, but also based on what I say. Your training of my training gave me a toolbox of techniques to guide the process of mediation, and that is what I think is a huge advantage for me to do now the mediation, that you are really trained.
Now, Mr. Bergman, when it comes to mediation, in terms of pay, how is that arranged between both parties?
Well, what I just told you something about the intake and the inequality of parties. So what is most fair is that parties will bear the cost equally, and that is also what is normally done when you reach an amicable settlement, that each party bear their own cost, or they share the cost of the mediator. Yeah.
So from the beginning, both parties are aware that they will have to share the cost.
Yeah, that is what I said before you start the mediation. You come to me and we talk about the subject, the conflict or the issue, what we say, and then we arrange and we agree on an hourly fee.
Oh, okay.
And what I will tell parties is what my expectation is, what the total cost will be. And then they can say if they agree or not, and then we make the final version of the mediation agreement. And then is when we start working. Okay. So, and then that is maybe good to tell you that you have the mediation agreement. That is in fact the instrument that I work with to do the mediation process. And you have a couple of sessions in which you try to come to a solution. Well, once that solution has been reached, then and parties formulate the way in how this amicable settlement will look like, then there will be a final agreement, and then it has to be worked into a final document, a legal document, a vaststellingsovereenkomst, what we say in Dutch, and then the dispute is resolved.
So once it's resolved, and this is quite hypothetical now, 4 months down the road, the party feel, well, hey, party B is not agreeing to what we agree on. Do they call you back or they run to court?
If they call me back together, then probably then they need another mediation. Because maybe one of the issues has not been resolved completely. But normally when it is in a vaststellingsovereenkomst, it is done. The dispute is settled, yeah.
So it's basically final and binding.
Yeah. The vaststellingsovereenkomst is binding, yeah.
So how you look at the future of mediation in St. Martin? You optimistic about it?
Yeah, I'm pretty optimistic about it. I was 2 weeks ago. I was in Curaçao. We also have a Curaçao office, and a lady who's working there is also specialized in mediation. So what we would like to do is to organize ourselves in a federation of mediators here and in Curaçao, and possibly also in Aruba. And then we present that to the bar association, and that we are organized as mediation and mediators, and that we are capable of handling the disputes based on mediation. And the good thing about organizing a kind of formal body or entity for mediators is that you also can have a standard with education and permanent education, and to make sure that if parties go to a mediator, it is an acknowledged one, and yeah. because it is not a protected profession, in fact. So what you could do is then to raise the standard and to say, okay, you did a certain litigation in Holland or in the States or whatever, so you can be acknowledged as a mediator here locally.
So it's recognized and
Yeah,
really.
yeah.
All right.
Yeah, that is a system where you should basically work on, and that will be the future, I think. That.
Okay. Well, Mr. Bergman, I want to thank you for being my guest on the program this evening, and thanks for coming and much success.
And thank you for having me.
All right, that's Mr. Rik Bergman. That's it for now. See you next time right here on Speaking of Everything. Till then, good night. Take care. Bye.